You know the story about Hunter Biden, but now we're going to get geeky about what it means for your Second Amendment rights going forward. We're going to break down the likely process heading out into the rest of 2024 for Hunter Biden. This is a very big deal for the Second Amendment because he's going to take an appeal into the court system arguing for your Second Amendment rights. That means we're going to have all of the baggage of Hunter Biden, the good and the bad and the ugly. So we're going to talk about what's going to happen in the courts, what to watch out for, and how to think about this case as it progresses. Because unfortunately, or fortunately, the Hunter Biden Second Amendment appeal is going to affect all of our rights. So we got to watch it carefully, and we got to get geeky, which we're about to do right here, right now. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Israel Disarmed, What the 10/7 Attack teaches Americans about the right to bear arms. A lot of important disarmament history there, mistakes that were made about not allowing a robust private armed citizenry in Israel. It went against a lot of lessons they had previously learned. The Jews in Israel were supposed to never forget what happened in World War II, yet they forgot many of those critical lessons. And we talk all about that in Israel Disarmed, not because we're happy to help the Israelis defend themselves and save innocent lives, of course. But really, I wrote this book to teach Americans about our right to keep and bear arms so we don't lose that precious right that we have. Yet another thwart, another effort, another item that we can use to thwart tyranny. Very important. I talk all about that in the relatively short book, Israel Disarmed. Check it out on Amazon. All right, folks, yes, I'm in a suit again. This is Fox News Day. If you see me in a suit, you can basically know what's going on. Fox News appearance today was Maria Bartiromo. Always nice to be on. My friend Maria, a great journalist and a great supporter of America. So always a pleasure to be on with her. Anyway, so let's talk about Hunter Biden, because this is very important. I know you're going to read a lot of stuff in the press, but if there's anything that I say that's inconsistent with what you hear in the press when it comes to the Second Amendment issues, you should probably assume that whatever you read in the press is not accurate, and what I'm saying here is probably more accurate. That should be your working assumption, because I think a lot of people, even constitutional writers and journalists who are pretty good, even conservative, they're not that sophisticated on some of these issues. So again, if there's something inconsistent between what they're writing and what I'm saying, odds are you should probably take what I'm saying as what's going to happen or what should happen or how to analyze these things. Just an observation. So let's talk about this. So Hunter Biden has just been convicted, as you know, of really two violations of the law. Violation number one is that he possessed a firearm while he was addicted and or a user of illegal drugs. And that violated 18 U.S.C. 922G, which says you cannot use illegal drugs and or be addicted to illegal drugs while at the same time possessing firearms. That's the essence of it, okay? Then, as a derivative kind of indictment, if you will, he also pled guilty, or didn't plead guilty, he was found guilty by a jury of lying on Form 4473 because he said he was not addicted and was not a user of illegal substances as that's defined. And the jury found that was a lie in October of 2018 when all this went down. And of course, we know he possessed the gun because he bought the gun at the gun store, and there was other testimony about that as well. So now he's been convicted. This is a pretty easy case from the prosecution's point of view. The biggest evidence they had was, of course, he talked. I believe he made several $1 million. I don't know for a fact, but he made a bunch of money in a book he wrote called Beautiful Things, I believe, where he talked about his drug use and his drug addiction. So he basically was using the fact that he was trying to recover from addiction, trying to recover from drug use, a laudable goal, by the way. But he was using this as a way to make money, which again is legal and fine, but it's very difficult in most cases, if you're out there bragging about or making money off, illicit crimes that you're committing, things that you're doing illegally, and that doesn't get the attention of prosecutors. Now, Hunter Biden should have been protected by the Department of Justice, and he was indeed protected, in my opinion, by the Department of Justice. And the only reason why this case got brought was because that sweetheart plea deal in front of Judge Noriega in Delaware fell apart when she started to ask questions about the scope and the details of it. And she said, this is ridiculous. And basically the whole thing fell apart under like 5 questions by Judge Noriega. Now, I should note, this is very important for you Second Amendment geeks, that you know Judge Noriega very favorably from this channel because she is the United States District Court judge in the District of Delaware that is I believe is the first judge ever in American history to actually write an opinion that says you and I, under our Second Amendment, have a right to make our own firearms. That's the first judge that's ever actually came out and said that. She said that in a decision where she declared the Delaware quote-unquote ghost gun or unserialized homemade gun law to be unconstitutional on a preliminary injunction basis, and she wrote that opinion. So Judge Noriega has historically a good record on the Second Amendment. Now, with that said, let's turn back to Hunter Biden. She's the one whose handful of questions unwound that sweetheart plea deal that was going to get Hunter out from on all sorts of tax problems and everything else, and most importantly, allow them to sweep this under the rug. When that fell apart, the Department of Justice had no choice with the special prosecutor to go after Hunter Biden and seek the indictments. Now, I do want to, before we get to the Second Amendment, make one critical observation. There is no doubt, in my opinion, that there is 2 systems of justice here, and the Hunter Biden versus Donald Trump proves the point. The left right now is in the media talking about how this proves there is no 2 systems of justice, that Hunter Biden was convicted, Donald Trump's convicted, and these are morally and legally equivalent, showing there is no 2 systems of justice. There's one justice system. That is utter, complete nonsense and BS. The reason I say that is because the justice system doesn't just consist of what's in court. It also consists of prosecutors. You ever watch the opening of like Law and Order? They say, well, the system of justice involves the prosecutors, the criminal defendants, the criminal justice system, the judges, blah, blah, blah. It's a system. Well, a big part of the system are prosecutors. And if you look at how prosecutors in the deep blue cities like Atlanta and New York City and the Department of Justice treat Donald Trump and his supporters, such as you and I, any chance they get, they look at every single thing and they go after Donald Trump and Donald Trump supporters, no matter what happens, okay? So they look at everything involving Donald Trump, and the only thing they could get on Donald Trump was this sort of BS charge in New York that wasn't even properly charged and clearly not even a crime in New York, and, for reasons we've talked about, is goofy. Now, with that said, in contrast, Hunter Biden's laptop has now been verified. It was verified apparently years ago. Now, what's interesting, and this is very important to understand this distinction, the Department of Justice under Merrick Garland, who was supposed to sit on the Supreme Court and replace who is now Neil Gorsuch, right? They were going to use Merrick Garland to replace Justice Scalia, and thank God to Mitch McConnell and Chuck Grassley for making sure that they did not hold hearings to replace Justice Scalia with Merrick Garland, who's turned out, in my view, to be the most partisan, anti-American, in my opinion, attorney general who's against the Constitution in all respects when it comes to anybody other than the Biden family and Biden supporters. So with that said, what's happening is the Department of Justice could have looked at everything on that laptop, everything involving Joe Biden, everything involving Hunter Biden, but instead, and this is the key, they laser focused on 2 issues involving Hunter Biden. Those 2 issues are what do they have in common? The gun crime is specific to the conduct of whom? Hunter Biden, right? It doesn't implicate anybody else in that issue. It's Hunter Biden himself using drugs and getting a gun. That's who's implicated in that crime. Nobody else's conduct matters to give rise to that crime. Then you have this case that's going to occur in September 2024 in California. And what is unique to that case? Guess what? That case is a tax case that says Hunter Biden himself violated various tax laws by taking deductions he should not have taken, I believe, by filing improper tax returns, by not filing tax returns, and so on and so on. So what does these things have in common? Both the tax case in California and the Delaware gun case force people, the prosecutors, to look at one single person, Hunter Biden and his conduct. But what is missing in the review? There is no investigation by this Department of Justice that I can tell of everyone else on that laptop, of Joe Biden's relationship with Hunter Biden. In other words, all those other things that could implicate anybody other than Joe Biden, this Department of Justice is not looking. Now, if this laptop belong to Donald Trump or any member of Donald Trump's family, in my view, then every single person referenced on that laptop would be in front of a grand jury, would be subpoenaed, would be interviewed, would be deposed, whatever it is, but that's not going on. So to me, the best evidence that there is two tiers of justice here is that everything that Donald Trump and Donald Trump supporters do are looked at under a microscope. In contrast to the Bidens, the only thing they look at is Hunter Biden and crimes that he allegedly committed by himself, implicating nobody else. They don't look at anything but those two things. They don't look at Hunter Biden's business associates. They don't look at Hunter Biden's father or family members, anything like that, to see if there's any other crimes being committed. And maybe there are, maybe there aren't. But the point is DOJ is only looking at things that allow them to laser focus on Hunter Biden and not implicate or risk implicating anybody else. That's why there's two tiers or two systems of justice. Now, going back to the Second Amendment issue, Hunter Biden is now going to seek a Second Amendment appeal, but that is not going to start, in my opinion, until sometime at the earliest this fall. Because the September tax trial is going to take place, I think, and this is my prediction, that Hunter Biden will not be sentenced in the Delaware gun case until after the California trial, because his lawyers are likely going to say to Judge Noriega, look, we want to try this case in California. We're very busy with that trial. Let us get through that, and then we'll come back and do a sentencing. And you know, and I know, I don't care what Joe Biden says, but the reality is Joe Biden is literally going, in my opinion, is going to pardon his son. It's simply going to happen, but it's not going to happen until after the election, whether either he wins and it doesn't matter, or he's lost and it doesn't matter. But I do not see any scenario where Joe Biden does not pardon Hunter Biden and Hunter Biden's associates and Hunter Biden's friends, is my guess. That's my prediction. We'll see what happens. Now, he's not going to say he's going to do this. He's going to say he's not going to pardon Hunter Biden. But after the election, I can't imagine him not pardoning Hunter Biden and anyone associated with Hunter Biden for all federal crimes. That's my best prediction. We'll see what happens. Now, what's going to happen on the Second Amendment appeal? Now, the reality is the facts of this case, there's no legal error. I don't see any way that Hunter Biden can win this appeal sort of on the facts or on the jury instructions. All this was right down the middle. There's nothing sort of odd about this case, ordinary criminal case. I don't think there's any viable appeal, in my opinion, involving the factual side or the jury instruction side of this case. With that said, I think that Hunter Biden's best argument is arguing that the Second Amendment right to keep and bear arms protects him, and the statute as applied to him is unconstitutional. Now, I want to say what's going to work and what's not going to work and what might work. What is not going to work on this appeal, in my view, is that Hunter Biden, and by the way, when I say appeal, that also involves what I expect to be a motion for a acquittal in front of Judge Noriega. So the first step, I think, is going to be a motion to acquit Hunter Biden, saying that he never should have been convicted, and then that will give rise to the same arguments on an appeal. So let's focus on the arguments are going to be. The first argument will be that 18 U.S.C. 922G as is facially unconstitutional, that it's simply unconstitutional to take guns away from drug users and drug addicts. That facial argument that says that the whole statute is unconstitutional in all circumstances as applied to all people, I think will fail. I think the court will say that there are certain instances where people using drugs cannot possess guns constitutionally under the Second Amendment, and therefore facially the statute is allowed to continue facially. However, I think Hunter's best argument is to say that, yes, we understand that 18 U.S.C. 922G as applied to drug users and drug addicts facially is constitutional, meaning there may be certain circumstances where it is applied constitutionally. But as to me, Hunter Biden, it is unconstitutional. And the reason, this is the argument I would make, and I think it's a valid argument, and I would say that, look, we're in the Third Circuit Court of Appeals, which gave us the Range versus Garland case that said non-violent felons, people convicted of felonies as defined by federal law who are not violent, do not lose their Second Amendment rights, period, full stop. And what I would say if I were Hunter Biden to say, look, yes, I used drugs and I had a gun, that's true. But the reality is there is simply no evidence in my entire life that I ever engaged in physical violence. There's no evidence in history that I beat somebody up, that I beat up my wife, that got into a bar fight, that I've shot someone, that I've engaged in any violence whatsoever. So yeah, I used drugs and I vegged out in the bathtub and I hung out and ate a lot of Doritos on the couch when I was high. Yeah, that's that's all true. But the touchstone, the critical thing that makes 18 U.S.C. 922G possibly constitutional is that it's designed to take guns away from physically violently dangerous people. And I am none of the above, period, full stop. So yes, I'm a drug user, and yes, that sucks. But the reality is that is not a basis through historical analog laws to show a historical regulation of people that abuse drugs or alcohol, anything like that. And therefore, as applied to me, this is unconstitutional. Now, if I use drugs and I was a violent drug person and I did all sorts of violence when I was on drugs, that might be one fact scenario that might be okay to take away my rights. But Hunter Biden's going to say that's not me. And again, I do think it's a legitimate, at the end of the day, in my view, the way you should draw the line for 922G prohibited people cases is there evidence that you are a physical violent danger to yourself or a physical violent danger to someone else? And I think that's where the Supreme Court's ultimately going to go. If you're Martha Stewart convicted of lying to the FBI, that's clearly nonviolent. There's no nonviolence. She can have a gun. She cannot be disarmed. If you are a violent murderer and you were a terrorist, guess what? You're a violent thug. You've been convicted of some terrible violent act. That's physical violence. You lose your gun rights. That is the spectrum. Martha Stewart on the one hand, violent terrorist thug on the other hand. The question is, where will drug users like Hunter Biden fall on that? Now, I think if you're a drug trafficker, a drug dealer, as to how that's defined, we can have a discussion of it in another video. But if you're actually caught doing drug trafficking or drug selling, then I think that's going to be viewed as a violent activity, because we saw that language from the Supreme Court of the United States versus Brown a few weeks ago that says that if you are engaged in selling drugs or drug trafficking, that is viewed as a violent activity, because the only way to enforce your contracts and agreements is through the threat of or the act of violence. In other words, if I'm a drug dealer and you don't pay me, I'm going to basically threaten to kill you. And that is, I think, where the Supreme Court is going to treat drug traffickers, drug dealers, as more like violent thugs. In contrast, where you have simply a drug user who has no evidence of physical violence, I think that is the tougher case. And I'm not sure where the Supreme Court's going to fall on this. Now, the truth is, this drug and gun case, I don't think is going to get before the U.S. Supreme Court for some number of years. Yes, the Daniels case is up there right now, pending cert, but I think the Supreme Court is simply not going to touch this issue for a couple terms. I think they're going to try to do some other Second Amendment cleanup first, is my best guess, before they turn back the 922. We also have some more indications of where they're going to go with 922G cases in the Rahimi case, which of course deals with 922G8, which of course says that if you're a subject to a domestic violence restraining order, you cannot touch guns. So I'm sure the Supreme Court is looking down the chessboard as to dealing with people like Hunter Biden years from now, and they're probably going to be thinking about this when they write the Rahimi decision, which we should have between now and July 1st. So there you have it, folks. Hope you learned a little bit something here today. And yes, you need to know all about this prohibited person stuff, even if you're not a felon, because the anti-gunners are trying to define everything in the world as a felony, as defined by federal law. So be very careful of this. They want to define jaywalking as a felony that will disarm you for life if they can get away with it. So don't kid yourself. These issues we're talking about involving felons and felons in possessions apply to all Americans, because I can assure you they want to make all of us felons if we drive 75 miles per hour in a 60 mile per hour zone. They want to turn that into a felony to disarm all Americans. Trust me, that's where the anti-gunners are going if they can get there. But you got places like the Four Boxes Diner and people like you that are going to work hard to stop them, and that is our intent, to stop them from violating our rights in all respects. So there you have it, folks. Don't forget to follow me on X at Four Boxes Diner. Subscribe and resubscribe. We're trying to get to 150,000 subscribers still. And make sure you check out my book on Amazon, Israel Disarmed. And we will see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.